All right, so political battles outside the court and inside the court, legal battles. The lawyers for the suspended ANC Secretary-General Ace Magashule have asked for a list of witnesses who have implicated him in the corruption case in the Free State. Of course, if we look back, it's alleged that in 2014, two companies, including Blackhead Consulting, were given the tender for hundreds of millions of rand. They subcontracted other companies. One reportedly did the work for 21 million, a small fraction of the tender that was offered. The initial survey of people living under asbestos roofs was reportedly not done properly, and whistleblowers say that more than 30,000 people still live under dangerous asbestos roofs. So what are Magashule's rights in this case? To discuss, we're joined by Mpumelelo Zikalala, who's the MD of Zikalala Attorneys. Mr. Zikalala, thank you for being with us. Are his lawyers allowed to ask and receive a list of witnesses ahead of time?
In fact, they are allowed. Let's remember that in the exchanging of statements between the parties, part of those statements is a brief details of the affidavits that have been deposed to by the witnesses involved. Let's remember, in order to prepare for trial and to prepare for the list of allegations that the person is going to face, in this case, the accused, they need to prepare themselves in line in what to be presented by the state. So in this case, the list of witnesses are going to be there. Brief details of what the witnesses are going to say in the witness box is also given to the defense. There are instances, though, where you want to hide the identity of the witnesses if you feel for their safety, if you feel that there is a high possibility they will no longer be available to you at a particular point in time. So they are hidden up until the time in which the court will require to come to the witness box and give the actual evidence. But in terms of what they're going to say, in terms of the witness list, that is basically provided. And they will even tell you that we have 2 or 3 witnesses which are going to be provided to you at a later stage, but we are going to give you ample opportunity in order to make sure that you're able to prepare for trial.
So then why has the state not provided a full list? The state advocate said today that they could revisit that request closer to the time, but he said he didn't want to bind himself to 5 or 10 witnesses, so trying to keep this open. Is that fair enough?
No, that's not fair, because it does not allow the defense to prepare for the matter adequately. So I felt in this case both sides were not really prepared, hence why the pre-trial conference could not proceed. For example, from the defense side, there were certain sort of legal reps that were missing the Section 212 capital B statements, which is the list of unopposed statements or admissions which are going to be made, which are there to curtail the list of witnesses that need to come in and collaborate stuff. And at the same time, the state, by not providing a full set of witnesses, is basically saying, you will only deal with the evidence which I have against you when you're at court. And that does not give you enough time to prepare, does not give you enough time to introduce and go and search for evidence which you can later use within that particular trial. So the instances for delays, I say, this time around, the portion must be blamed on both sides.
Yeah, so you suspect that soon the judge will say that list has to be finalised or finalised as far as possible, and it has to be given to the alleged perpetrators here.
Definitely. And let's also look at the amount of time in which they were given. The issue of 3 weeks was very sort of topical, in certain instances in which the judge even said the lead counsels that are there must be able to find stands-in or substitutes which are going to come in and deal with that matter for that particular day only. Because all that the judge is interested in at this particular moment is for the trial to start and for the trial date to be arranged and all the pre-trial requirements to be done away with, certainly before the end of this year.
All right, there is one witness that everybody knows about, and it's a bone of contention, the legal status of a key witness who's now based in the United States, that is Muradi Cholota, who was Ace Magashule's personal assistant when he was the Premier of the Free State. So the defense is saying that she's their witness. The state is saying that she's a state witness. Why does that have to be so clearly defined? Why can't she just testify? And I guess it will be very interesting what that witness has to say.
I think it depends on which side the witness is going to collaborate. Is it that of the state or that of the defense? In this case, I'm certainly sure that the judge or the court is going to say, we are very interested into the contents of your evidence. We want to test it. We want to be able to sort of know exactly what you are going to say. And with them being declared as such at this early stage, there is a high chance that they may be declared as a hostile witness at a later stage, in which wherever party would say, you did not come to my favor or did not present evidence that absolved me or assisted me in making sure that I'm able to present the accused as being guilty beyond reasonable doubt. Your failure to do that, I have to declare as a hostile witness. I have to declare you as a person who was not speaking the truth, because you did not really assist me in terms of what I was doing. But at this stage, up until this particular pre-trial conference has been concluded, up until that particular witness list has been passed over and handed over to the defense, we cannot say who that particular witness is going to belong to.
Yeah, I think everybody wants to hear what she has to say. All right, explain. Nobody seems happy with the delay. This is a pre-trial. Just tell us why there needed to be a pre-trial and then going to this case. Apparently 300,000 pages of documentation, a lot of evidence. What do you think about the state's case? Obviously, you don't know everything, but around what you've heard.
Now, let's separate the two processes. Let's start with the list of statements which is going to be given to a number of accused. Now, the Section 212 capital B statements are important because the more admissions in which you provide to the state, the lesser witnesses and lesser evidence that they would need to bring against you. So even if a witness would come in and say, yes, I do agree that I appointed Mr. Ace Magashule to be the Premier of the Free State at this particular point in time. There was a list of transactions and tenders that took place on this date. Now, if that is admitted at the onset, it eliminates those numbers of witnesses from coming to court. So it makes the days in which you are going to spend in court much shorter. It allows the parties to focus only on the disputed facts and allows the court to only concentrate on those ones. The idea or the intention being we'll have a lesser number of witnesses, a lesser number of court days, and crisp arguments when it comes to the determination as who is guilty and who is not guilty, which is why this pre-trial conference stage is very important, because if you do it correctly, then you are able to have a trial process which is short, which is swift, straight to the point, and is able to start and end within the shortest amount of time. You are doing that in compliance with Section 35 of the Constitution, which does indeed say a trial must start and end within the shortest amount of time. Failure to do that, you are contravening a person's right in terms of Section 35, and that may just collapse the whole case against them.
Yeah. All right. So the pre-trial, very important. Very quickly, you've heard what the state has been saying around its own case. Does it sound like they have something that's watertight or something that holes could be poked in, as it were?
I think for now, due to the number of accused that are there, it's going to be quite difficult for the state to consolidate all of them. I think they were kind of hoping that there are certain people who are going to turn state witnesses. There are certain people who are going to say, we want to assist, we don't want to be part of this. Just tell us what you need from us, and then we'll provide that particular information. However, it seems as if it's going to be an uphill battle. It seems as if there are going to be many trials within trials up until this particular trial is completed. So it is not going to be an easy run, but they're also making it difficult for themselves in terms of not being prepared in time, not making sure which they are always ready to deal with this particular matter. If a state goes to court and says, I'm ready, judge, the only people who are not ready is the state, they stand a much better chance of proving and also sort of consolidating that public confidence into making sure that they have done their job, they are ready for the prosecution, and indeed the evidence that they have is going to be able to prove the guiltiness of the accused beyond reasonable doubt.
All right, fascinating. Thank you very much for your insight tonight. Mpumelelo Zikalala, legal analyst and director at Zikalala Attorneys.